Hey guys, Sarah Boone, who puts the pen in penitentiary, has written another letter to the judge. And she's not taking things any easier than she has before. She seems to be maybe have dialed the upset knob to 11. Let's see what she has to say. Let's take a look. See if I can bring it in here. Okay, here it comes. All right. Well, it starts off, well, it's addressed to three people: the judge, her attorney, and the whole wide world. So on behalf of the whole wide world, I'll share this with you. If you know anyone from a different planet, don't let them see this. Perspective. And then she talks about that word. I wonder how many people are going to actually look up the definition to see if it's the same. I'm not going to. I wonder also how many website hits the word perspective will get. I don't know. So she outlines the definition of that. I think we get that. Okay, now she starts ordering the judge around, plus I suppose everybody else on the planet. Please review so everyone has a clearer, better understanding of my continued concerns and hindrances, questions and frustrations with the justice system, and the solid, absolute remissness, of my case, and the due process of I am and have been waiting very patiently and maintaining what I can, since no one else has, or will, it seems. And I feel at this point, 6 attorneys later, 39 months, almost 3.5 years. She likes giving a little list with dates and times and things on it. It's kind of very Rain Woman-esque, Wapner at 5 kind of a scenario, and not by choice. I need to make all aware of my immense struggle with extreme mismanagement of my case to date. Okay, well, let's see just how bad this is. Let's look at the bigger picture or perspective. See, she calls back to the beginning of her letter to keep this narrative flow going, to let you know that she had a thought process for this thing, to get a better view of what I've had more than enough time to see and realize. I'm hoping by doing so, eyes can finally be opened and very overdue, longed for progress and finalization can be had. The growing amass of ignorance, manipulation, slander, and advantageous gain, it must stop. This all has to stop. My truth needs to be heard, and it is my right. Now, I think one thing you'll see in this letter, though, she never tells what allegedly her truth is, but whatever, it needs to be heard, just not right now, I guess, not when she's doing this letter. Do not give me rights expecting me not to fully utilize them. I voted for the president and governor while here in jail, and stop violating what I've been trying to utilize or lessen the value of my capabilities and opportunities. Okay? I am not apologetic in any way for being an observant, hardworking, above average, non-stereotypical inmate. I can only imagine, sadly, how others, not as outspoken as myself, have been and are being mistreated, overlooked, and dehumanized. Get it together, justice system and world. Judge Wayne Wooten. This is for him. We'll read it anyway, since she also put it in the letter to the world. At what point do you evaluate and intercede in a case to make sure there's proper advancement, regular communication between the attorney-client, ethical treatment of the client is being upheld, time frames are being met, etc.? This is all underlined to make sure he gets the picture. He needs to check into this right now. She's no longer just asking for the manager of the justice system. She's asking for the manager of the whole planet. So the judge, he needs to start sweating a little bit. Clearly, you know of and have known of the prolongation of my difficulties from your comments regarding my letters, but with no intervention from you to change anything for a better, less problematic process. You've told me in the past, when I've tried to voice my legitimate concerns to you in the courtroom, 5 times total in 3.3 years, Wapner at 5, and in my letters to save it for the next attorney, if told anything at all. Do tell, Your Honor, which attorney? Well, it says next one. So your answer is in your own letter. I'm on my 6th, whom I've not seen in person for over another 3-month period, 12 weeks, 89 days. Wapner and County. Frank Bankowitz has been appointed as my attorney by the court to represent me in my case, and has been for 10 months and counting. Total approximate hours of representation, 7,200. Again, it appears she has some kind of mental disorder here. Total times attorney met with client, Sarah Boone. Right, the one writing the letter. 6. Phone calls given to client by attorney, 2. Phone calls answered from client by attorney, 0. Outside sources calling attorney on behalf of client, 3. Phone calls, emails, voicemails answered by attorney, 0. Letters client sent to attorney trying to communicate, 7. Letters defendant/client sent to judge trying to communicate. Animate attorney in unsuccessfulness, 5. 15-minute video visits between attorney and client, 3. Attended court dates scheduled, 2. 1 was an attempted withdrawal, the other an allowance to finally be included in my pretrial conference, which was the same information carried over from all the others. Now what? Well, I think now would be a good time for you to get involved in a fantasy football league or something, because with your affinity for stats and tracking every single thing, you could score some stuff out of the canteen there. I feel confident you would be on the winning side. Why are you allowing/enabling my constitutional rights to be continuously violated? And some of you may think, well, what constitutional rights? Well, here's the history lesson for everyone. First, which is in parentheses, has a 1 in the ST, so we know first means first. First Amendment, Fourth Amendment, Fifth Amendment, Sixth Amendment, Eighth Amendment, 14th Amendment. I think you could have thrown some more in there, but that's a good list. Why am I being judged for my legitimate letters I write in order to know the status of my case or attorney, and how much longer before something substantial occurs in the progress of 3.3 years later, other than the inappropriate prejudgments being made due to the excessive amount of my case information online, bigger and meaner fabrications of my case-sensitive details in which I have not seen, and even greater mind-numbing one-sided ignorance. Well, how do you know people are sharing your sensitive case details if you haven't seen them sharing your case-sensitive details? If I didn't write my letters, would you or anyone be aware of all my rightful concerns still and ongoing? Yeah, I don't know. Is a perpetual question mark over a defendant's head the norm during a case due to inactivity, no communication, no help or intervention, or answers being given by anyone in the justice system? Honestly, what has been done about or with any of my letters other than being scanned/uploaded incorrectly? I made sure to correct so everyone is up to speed on my case status. I know money's tight in prison, but I feel like they should issue her out some more periods because she's not using them enough in this letter. Unfortunately, it is all I have to report at this time. Paragraph 4. Why are you allowing numerous case safety and protection elements to be breached, violated, and manipulated? Why has a gag order never been implemented? Case safety. The only person who's dangerous in this thing is you, and you're in jail. So I'm not sure whose safety is being violated. Nobody's being threatened or whatever. My case has been turned into an unnecessary witch hunt. Well, not really. It's not a hunt, see, because they found you and you are in jail. So it's more of a talking about the witch thing if you're the witch in this scenario, which I think you are the witch. Which, speaking of, let's continue. From the innumerable violations of my case details being leaked and racketeered illegally in exchange for website hits, viewer ratings, etc., in exchange for dollars. I don't think it's really leaked, right? It's information that's in a public domain and record. And I get it. You don't want people to see that video of you with your boyfriend locked up in a suitcase laughing while he's dying. What is your cut, Your Honor? So then, see, the judge is in on it. The judge, she says, is getting a share of this YouTube website revenue, right? That's a good way to get the judge on your side, is to go ahead and accuse them of corruption with zero evidence at all, because things from your case are online when things from pretty much all cases are online, generally speaking. You choose who knows what, where, and how in your courtroom. When did court minutes become live? Are you the one who authorizes the upload to the internet? It's all about how much rather than how did it happen. No matter the destruction caused in the meantime, it is irreparable. Well, what was that destruction? I mean, you're waiting for your case to go forward, right? And you're trying to find somebody who will say you were a battered spouse or whatever. It's not even about the suitcase anymore. No, it's pretty much about the suitcase. It's pretty much about your boyfriend being in a suitcase zipped up, begging you to let him out and you didn't, and whether that constitutes murder or something less or whatever, that is what it's about. My case is now a global event with the video receiving over 3 million hits. She does put 3 million in parentheses to make sure we know that number's right, depending on the website, in turn making me realize that's over 3 million less unprejudiced, unbiased, non-discriminatory, fair jurors I will have access to on my case. Now, see, here's the thing. Those people would see that video anyway if they're going to be on the jury, and you're not necessarily prejudiced or biased just because you saw some factual, actual evidence in the case. I know there's a thing online where people think if any juror heard anything about any case, instantly they're disqualified. Instantly the case must go under gag order. Instantly the case has to be moved somewhere else, but it's not the law. How's it going to work? Well, you're going to find that out. They're going to seat a jury who hasn't seen your video, or if they did, don't care or have a conclusion about what it represented, and you'll go to trial. Now what? Well, you'll find out. Factoring. Important private details should not be made ready and available for the world to know before I, the defendant, does, correct? Well, but you're the only person who was there, so you do know all of it. The only question you could have is, what is it that you know that other people, and most specifically the government, the police, and the DA know, right? I mean, that's your only question, is how much of what you did do they know? Because you know all of it because you're the person who was there. This is wrong, unconstitutional, unfair, and not how justice is supposed to work for anyone. A constitutional expert, Sarah Boone, has rendered a verdict here. I'm tired of having motives attributed to me that are unreal, assumed, and inappropriate. This is not legal. Okay? You know, oops, sorry about that. I might disagree with that, except she underlined it, so I know that has to be right. This is what a trial is for, correct? No, the trial's where all that evidence gets put against you and you mount whatever defense you want, and the jury decides whether you committed all the elements of the crime beyond a reasonable doubt. That's kind of what the trial's for. At this point, what can even be rightfully suppressed in my case? Once you ring the bell, it can't be unrung. Well, here's the thing about ringing a bell. When the ringing of the bell is a video of you laughing at the guy that's locked in a suitcase, they're going to ring that in the courtroom. Like, people are going to see that. And I know you didn't want to watch it when the police try to show it to you, but the jury is going to see it, assuming you do carry this thing on to trial. It's already been heard and seen. I don't even know where the bell is or who's ringing it. Yeah, it's terrible, but you're the one who recorded it. When do I, the main component in my case, actually get to know/see/hear everything everyone else already has? When am I going to be included also? What is it you're worried about them having that you don't know about? Since, again, you were the only other person in the room besides the person who died who you were laughing at on the video. I don't buy that. When is the next status hearing you stated would happen before my pretrial conference, July 11th, 2023, which is my attorney's 1 year mark, Wapner at 5, am I included? What else can I do to ensure the productivity, communication, incorruptibility, appropriation, and intellectualism of my case? Somebody got a thesaurus as a present. It is my right to know so I can begin or continue for true progress of any kind to finally be succeeded. Well, but it was your side asking for continuance last time because you were struggling to find an expert who would say you're a battered spouse syndrome. Otherwise, you could have gone to trial. I get it, though. You want to go there, and you want to have people who testify for you, and maybe you'll find one. Now we switch from the judge to the attorney. Where are you? Our last in-person was February 15, 2023, 3 months. When is our next meeting? Remember, please, there are still time-sensitive matters pressing. FYI, in the 10 months of your representation, here are the 6 meeting dates which have occurred so you could see prospectively. See, he's still calling back. This is the fluid narrative going on here. The massive time gaps in between while I have been sitting eagerly, waiting and wondering. Then she gives the list of the times they communicated and the times they didn't. And then she goes back into IT mode, very upset about this telephone situation. Why aren't you fixing either of the 2 phone numbers you gave me upon your appointment back in July? Parentheses 11, 2022. Every time I ask you about, it's a different excuse. Much progress can be made in a very expeditious manner if completed. Okay, that didn't make sense. Why has it not almost a year later? Why do you keep telling me to call when you know they don't work? As said before, public defenders answer their calls and reply to mail. Why are you unable or unwilling? See the difference it will make. Our agreement made from one of my letters I wrote earlier this year after not hearing from you in a solid 5 months prior was to connect every 2 weeks with or without any significant progress. Why have you not been upholding this agreement, even in a 15-minute video visit? Remember, a phone call is another option and not as difficult technologically. A working number is needed, though, just one. What are your anticipated dates of completion for anything already discussed? And will eventually, when do you actually show up for an in-person scheduled meeting? There are 1,000 little fires needing to be put out. You're holding the fire hose. He may be holding the fire hose, but you're the one who started the fires there. So that's kind of a problem. You got to work together. Please see from my perspective the botched, eye-rolling experience I am going through still, and how I believe anyone would act or do if I think that says slides. I can't read that. Doing the same. What would you do? Do not fault me in trying to make the best, most successful outcome possible for myself in every aspect in the convoluted predicament I am in and have been over the last 3.3 years. And no one should falter for that. I mean, she wants someone to pay attention to her case, and she wants to have it move forward. And those are the two things that she's correct about. I'd rather be called a narcissist, pain in the ass, arrogant, strange, or whatever else anyone wants to waste their time to think of. Those are a good start. Just don't call me a murderer, which I am not. Well, we'll see about that. No one knows me except for the ludicrous insanity that's been made up, mocked, edited, and spewed all over the internet. It's not me. Maybe not, but these letters aren't really changing that opinion, I think, as much as you wish they were, in that they represent a zero introspection. That's another multisyllabic word. Maybe you get to that in your thesaurus and you can use it for the next letter. Try it out. I'm hoping and praying my highly anticipated day will come, whenever that will be. It's God's timing. I continue to wait smiling. I don't know that I believe she was smiling at all points during the writing of this letter. At least everyone will know I'm not sitting around eating bonbons and watching soap operas. Okay, thank you for checking in from the 1980s. Application is the product of the lesson. And also your burgeoning, blossoming fortune cookie slogan writing career seems to be taking off as well. Give me my chance appropriately, correctly, and fairly in court. Unfortunately, my perspective of our justice system is incredibly dim and dull. I hope my very overdue blinding light has shone brightly for all to see a glimpse of how it really works. And being a system, we all have to work together to function in unison. Please help see the difference I'm trying to be and make waiting and wondering. Keeping it real. Now what? Well, now what's going to happen is that the court's going to do that one-page form where they check correspondence received. You don't need to do anything further. And then I think you'll either be seen in court again if they do a status conference, or at your final pretrial conference. And we'll see if you found an expert who will help you out and see what you come up with. Well, that's it. Thanks. Bye.